Defendant then served its notice of hearing on September 5th, 2023, setting today, October 23rd, as the date for the hearing. Did we lose you? Looks like we might have lost Judge Hoffman.
Sorry, I disappeared there for a second. Go ahead.
On September 5th, we sent our notice of hearing for today's hearing on this motion to transfer venue. That gave plaintiff 48 days notice of the hearing, which is compliant with the 45 days required. Rule 87.1 then requires that any response or opposing affidavits be made at least 30 days prior to the hearing on the motion. That means that plaintiff's deadline to file a response to this motion was on September 25th, 2023. Plaintiff did not file a timely response, instead filed a response on October 16th, 2023, only 7 days prior to this hearing, and unfortunately 21 days too late past the deadline. Therefore, the court should not consider plaintiff's untimely response and should only be looking to the timely filed pleadings in this matter. Now, that would limit the inquiry to plaintiff's live petition, which is still their original petition on file, and defendant's verified motion to transfer venue. Plaintiff's petition alleges.
Let's deal with that issue first about the untimeliness of the response. So, response.
Your Honor, I think the reason that it was past the 30 days was because we were trying to confer with defendant's counsel to see if this hearing was even necessary, given that we think based on the permissive statute, it's clear that venue is proper in Dallas County. My colleague, Mr. McKenzie, was handling those conversations that I was not privy to, but that is my understanding as to why he filed later. Oh, and you're gone again. Okay.
I'm still here.
Oh, you are. Okay, sorry. I thought you vanished. So that is my understanding as to what has happened in this case, and that's why it was not filed immediately, because we did not want to waste the court's time and precious resources listening. If we could come to an agreement, or if defendant's counsel of Methodist Hospital of Dallas was willing to withdraw or their motion.
Okay.
Your Honor, if I may, there have been no previous conversations except for when we were in your presence last, about 10 days ago. So I think it was Friday the 13th, I think, when we were there for a motion to dismiss. That was the first time that plaintiff had ever even mentioned anything about the motion to transfer venue, and did not, ask us to about transferring venue or not transferring or withdrawing our motion until at least on the 16th, which was also the same day that their response was filed. There was never any communications prior to their deadline. And so therefore, we see no reason or good cause why that the response should be considered as timely.
Your Honor, it's my understanding that during that hearing that Mr. McKenzie appeared to, instead of myself, that it was discussed with Your Honor the merits of this motion to transfer venue, and that there was an indication that Dallas County is a completely proper venue and there shouldn't be a reason to even be arguing this at all. But defense counsel indicated that they wanted to move forward and have the hearing. And so that's when we filed our response, which is a total of 7 pages. Unfortunately, it was outside of the timeline that is required. I don't know if it's incredibly hard to digest, though, our main argument. And it's my understanding that's why Mr. McKenzie waited to file it at that time, to see if it was even necessary to discuss further.
All right, so I'm looking at the rule here. It's 87.1. Kind of seemed. So you're so under 33, sorry, Rule 87, subsection 1, it says, except on leave of except on leave of court, any response or opposing affidavit shall be filed at least 30 days prior to the hearing of the motion to transfer. The movement is not required to file a reply to the response, but any reply and any additional affidavits must supporting the motion transfer must, except on leave of court, be filed not later than 7 days. So when was the response filed again? Let me see.
The response was filed on October 16th.
Okay, so 7 days in advance. And was there leave of court requested with the response?
There was not, Your Honor.
And why didn't you request leave of court?
Your Honor, I think my understanding is that Mr. McKenzie didn't think we needed to, but I mean, my office can certainly file that and raise the same arguments that I've raised here as to why it should still be considered by this court. Our response.
Okay. So is there any case law on this, on whether or not a leave of court has to be written, or can it be oral?
Frankly, I am not sure if there is any case law specific that are being written or oral, Your Honor.
If it can be delivered oral, I would orally now request leave of court to still be able to make plaintiff's arguments as to why Dallas County should still be considered proper venue in this matter.
I mean, the purpose of the rule, that obviously the way it's written, is that you want to give the defendant an opportunity to file a reply. I will tell you, I've dealt with this almost identical issue in a number of cases, and have always, I don't remember if it was this hospital chain or not, but I'm pretty sure it is. And I've always denied the transfer, but, you know, I haven't had this issue raised about whether or not leave has to be requested in writing, or it can be done orally. I think at the very least, if it's allowed orally, Mr. Moody, you should have an opportunity for additional time to be able to file a reply, if you want to.
Yes, Your Honor. I think you know, part of our problem is that we are ready to kind of get the ball rolling on this case, but to do that, we feel that it should be where venue is proper, and we just don't feel that venue is proper in Dallas County. One, based on the way that it was pleaded in the petition, and two, even without it necessarily being an untimely response, it's still
So I'm going to give you, Mr. Moody, I'm going to give you kind of two choices. We can go forward today, and I'm going to consider their response. Or if you want extra time, because I do think it's only fair that you have time to file a reply, and when they filed that, they didn't really give you that time. I'm happy to reset the hearing in 2 or 3 weeks. You know, I think you have a scheduling conference up. We could even do the day of the scheduling conference if you want time for a reply, but that's kind of your choice. Do you want an extension so you can do a reply, or do you want to waive your objection for the timing?
I think, you know, we can, I guess, go ahead and go forward with this. Something that we've argued in the past. So, yeah, to my knowledge, everything is pretty much the same as other circumstances we've gone before. So,
okay, let's go forward. All right, go ahead and go forward with your merits argument.
So, Your Honor, first and foremost, plaintiff's petition alleges that venue is proper only because of section 15.002A1. In their response, they state that it's proper because of the principal location or principal office of the defendant, but rather their petition actually states that it is based on all or substantial part of the events giving rise to the claim that they say occurred in Dallas County. Now, when we filed our motion to transfer venue, we allege that all the medical care and treatment for plaintiff actually occurred in Collin County, where the hospital is located and where the other defendant's practice is located. All of the care occurred at those two locations, which is what is being alleged as negligent in this matter. All of that care occurred in Collin County, and therefore Collin County would be proper in this instance. Now, the Texas Supreme Court in NRA Signature Care Emergency Center, cited at 665 Southwest 3rd, 150, an opinion that was delivered in March of this year. The court stated that once venue was specifically denied, when defendants specifically denied the alleged venue facts, the plaintiffs had the burden to then present a prima facie proof that venue was proper in the county of suit. In this case, we still don't believe that that is proper. We don't believe that the defendants supported anything in their live petition that they alleged venue was proper. They did not deny any venue facts that defendant pleaded, stating that all or substantial part of the events occurred in Collin County. Defendant instead made a subsequent argument pivoting from their substantial part of the events or circumstances giving rise to the claim, alleging that venue was proper pursuant to, I believe it was 15.002A3. And frankly, in that, plaintiff or defendant Methodist has, while yes, we have a corporate location in Dallas, the office that directs, controls, and decides the daily and everyday functions of the hospital, where the nurse in charge is, where the training occurs for that hospital, where there's specific hospital policies, those occur at the location of the hospital where that hospital is licensed to practice care. The hospital cannot practice at its corporate location. That's not where it's licensed. Methodist Richardson is licensed at the Methodist Richardson location, which is in Collin County. We cannot practice in Dallas County, and therefore the actual principal office where the decisions are being made, where schedules are being made, where policies are being made for that specific hospital occur in Collin County.
So you're kind of making two arguments. You're arguing one, that it wasn't pled correctly because it's pleading that everything happened there, but even if it didn't, then the principal place of business is actually Collin County. Is that kind of it's really two steps?
Correct, Your Honor.
All right, response?
So defendant is correct that plaintiff has the chance to prove through prima facie evidence that venue is proper in Dallas, and we believe from our response that we have done so. First off, the principal place of business of Methodist Hospitals of Dallas is Dallas County, according to the charter filed with the Texas Secretary of State, along with other Secretary of State filings that indicate that their principal place of business is 1441 North Beckley Avenue, which is in Dallas County. Also, their executive officers, including their board members, CEOs, COOs, executives, are all listed at that same Beckley address in Dallas County. Further, on their hospital website, their LinkedIn profile are all listed as a Dallas County-based hospital. I think it's hard to argue that principal place of business of Methodist Hospital is not in Dallas County. Therefore, Dallas County is a proper permissive venue under section 15.002A3. Further, Dallas County is convenient venue for all the parties in this matter. Even if you base it on their alleged principal place of business in Richardson, that office is 0.1 miles closer to the Dallas County Courthouse than the Collin County Courthouse. Also, all of defendants' counsel are located in downtown Dallas. Defendant has not.
Don't worry about the convenience argument. I agree Dallas is just as convenient, if not more so than Collin, but
okay.
The initial concern I have is your pleading is that you pled it as all or substantial portion of the malpractice occurred or alleged malpractice occurred and that's not really your basis. Your basis is really their principal place of business, correct?
Yes, that's correct.
Did you ever amend your pleadings?
I don't believe we did, but I can check the record.
There was no amended pleading, Your Honor.
Okay.
I don't see one.
But our main argument is still that under the permissive venue statute, that because of the principal place of business.
But you didn't. I agree with you, but you didn't plead that.
Mm-hmm. Right.
That's the problem. Is that.
I still think that we did meet our burden of providing enough prima facie evidence that venue is still proper in Dallas, even given the petition.
Is there any case law on this about so under Texas Rules of Civil Procedure 63 and the Watson v. City of Odessa case, it says the plaintiff may add or drop claims from its original petition to establish venue. The plaintiffs must file an amended petition at least 7 days before the hearing.
Mm-hmm.
Did they raise this in their motion to transfer venue that you guys, this is how you pled it?
I do not recall defense counsel doing so, but their argument was based on the events occurring in Collin County.
Your Honor, we did in fact state in our motion to transfer venue on page 1, at the end of page 1, beginning on page 2, plaintiff filed the suit alleging venue is proper and maintainable in Dallas County under section 15.002A1.
But I will say your motion also does say the court is requested to take judicial notice of the fact that Methodist Hospital Dallas is located in okay, let's see. So Women's Health Associates of Richardson, that's located in Collin County as well.
Yes, Your Honor.
And Charles R. Downing is.
Correct.
And then Methodist Hospitals of Dallas, DBA Methodist Richardson Medical Center. Is that actually a DBA, or is Methodist Hospitals of Dallas a parent company of Methodist Richardson Medical Center?
It's a DBA. Methodist Richardson has its own location, its own license specific to Methodist Richardson Medical Center to operate at its current location, which is in Collin County.
Okay, but Methodist Hospitals of Dallas, Methodist Richardson's a DBA of Methodist Hospitals of Dallas.
Yes, Your Honor.
Okay.
And even though it's a DBA, all of that care and treatment that's at issue in this case.
I understand that. I understand that point. I'm trying to figure out the Methodist Hospitals of Dallas. She says that their CEO is located on Beckley, which is in Dallas County, right?
Yeah, that location would be in Dallas County.
So what I guess I'm not making myself very clear. I apologize for that. Is I guess my understanding, I don't remember I've dealt with Methodist, is usually there's like a parent corporation, and then each of the individual hospitals may have their own separate entity, but they're under one umbrella. That's not the case here.
No, in this case, they are technically under the Methodist Hospitals of Dallas, but they also have their own leadership team at Methodist Richardson.
So is it all just one entity then?
Technically, yes, because it's all technically under Methodist Hospitals of Dallas.
And Methodist Hospitals of Dallas, their CEO is located in Dallas County.
Yes, I believe so.
Okay, Mr. Cottrell, I just want to, y'all have mispled this and filed a late response. You're not making my job very easy here. I don't typically want to transfer cases away, but this was pled incorrectly, and it was the response was late in this case.
I understand, Your Honor, and I do apologize on behalf of the firm here and on plaintiff's behalf. I do think that venue is still proper in this matter, and that I think it's given the location of the principal place of business and the convenience for all parties. It's supposed to be plaintiff's power to choose in which venue they file, and we have not made your job easy, and I apologize for that. But I do think it's still permissive and proper in Dallas County, and that no parties would face an injustice by having to litigate this case in Dallas County.
I don't disagree with any of that, but if you guys had simply pled this would have been a slam dunk if you guys would simply have pled this as their principal place of business being in Dallas, and you had filed it on time, we wouldn't have any of these issues. I mean, this is.
I understand, and if you would like, we can file an amended petition and request leave to for Your Honor to consider our response, even though it was untimely, or however you want to proceed. We are happy to do that for Your Honor to try to mitigate the effects of the late filings.
Mr. Moody, I guess what I'm looking at here is that I want to be fair to your side. You know, I've dealt with this exact issue before, and I've never really transferred venue. But in this case, because of the way they pled this, I don't think it's fair to you I don't really think it's fair to you to deny the motion to transfer venue because because of their screw up. And so I want to allow you an opportunity to amend your motion to transfer venue. Your motion is a little unclear. When I read it the first time, I assumed that they had properly pled this, that Methodist was a Dallas, but now that I reread it, I can see how it could be interpreted either way. So do you want an opportunity to amend your motion to transfer to deal with their correct allegation, or the allegation they are now making, or what do you want to do?
I guess, Your Honor, it's kind of stuck in between a hard place here. We think because, the untimely response and the,
I totally get that. I totally get that. If I were you, I would probably, be raising my arms up and, judge, this isn't fair. They screwed up, and they did screw up. I don't like these types of decisions to be made that way. And so, but I do also recognize that it's not fair to you that you thought you were shooting at one target and now they've changed the target. And so I'm trying to kind of split the baby, give you an opportunity to redo you haven't done anything wrong here. I just want to make that clear. Because based on the way it was pled, you pled this correct. I mean, you did the proper motion to transfer. But I'm going to allow them to replead. So I'm going to give you an opportunity to refile or amend your motion to transfer venue or whatever you want to do. I'll just say that I have dealt with this issue a number of times. I try to be I haven't dealt with the issue of someone pleading it incorrectly and filing a late response. That makes this more difficult, but I feel like I should be on the merits consistent. But there may be something here that I'm just not seeing that might make it, I don't know exactly the corporate structure of Methodist Hospice. I think I've dealt mostly with Baylor, and Baylor has this kind of issue. And the way they do it, I think is, if I recall correctly, is they have a, big Baylor, and then they have all these individual little Baylors. And I assume that's how Methodist does it, but that may not be the case. And so I want to give you the opportunity, if you feel like you want to go into and look at more, provide a new affidavit and say, hey, Judge, no, that's not how it is. This is how our corporate structure is, and this is why the principal place of business is actually Collin County. If that's the case, I don't feel like it's fair to let you to make a to prejudice you in that way if you want to try to make that argument because they didn't plead it correctly. Does that make sense?
It does, Your Honor, and I appreciate that.
What do you want to do?
We can we'll take the opportunity to amend our motion to transfer venue so that we can address those issues as well.
And Ms. Cottrell, you need to talk to I know your firm, you're a good firm, but someone dropped the ball along the way. And so I don't know who drafted this petition and who filed this response, but you need to talk to Ben and the other folks there and say, hey, look, the judge got, kind of gave us a break here. It may not happen again. And so we need to make sure that we fix this.
I appreciate that, Your Honor. And yes, I will make sure that my colleagues understand that this is not how we should be conducting ourselves in your court or anybody's courtroom.
Okay. All right, guys. So how do you want me to handle this, Mr. Moody? Do you want to just pass the hearing and why don't you prepare an order that says that I'm giving you additional time to amend your motion because of the pleading defects, and then I'm granted leave for them to file a late response and amended petition. Now I will say this, and I want to make this clear on the record, Ms. Cottrell, is if you don't amend your petition and this happens again, I am going to transfer venue. You need to amend that petition.
Understood, Your Honor. Thank you.
All right. Sorry, Mr. Moody.
Sorry, Your Honor. How much time would you like us to give in between, for us just to amend our petition? Do you want us to go ahead and redo that 45-day time period, or?
What do you feel is fair?
frankly, I feel like we could probably get a response on file probably by the end of the week, to be honest, by Monday of next week.
You mean an amended motion on file?
Yeah, and then I'm assuming it's really gonna be geared towards just a response, basically or reply pretty much to their.
Okay, so you could file a reply brief. That makes sense. I'll give you an opportunity to file a reply brief and an amended motion. So put in the order that we've granted them leave to file a late response, granted them leave to amend their petition, that you have, Ms. Cottrell, until Wednesday to file that amended petition. If you fail to, then you're not going to be allowed to amend the petition. And do you want to reset this like in 21 days? Does that sound good, Mr. Moody?
Yeah, Your Honor, that sounds good to us.
Your Honor, just to make sure I'm clear, so we need to file the amended petition, and then our response that we have already filed, that will be considered the response to their amended motion. Is that
Right.
correct?
Well, it's really,
Okay.
it's going to be an amended motion in reply. Is really what it's going to be. So.
Okay, so we will not have, we will not have an opportunity to respond to theirs. Our response as it is will be taken as it is, correct?
That's correct.
Okay.
So November 13th, how does that sound, Mr. Moody?
I think November 13th works for us, Your Honor.
All right, we'll do November 13th at 2 o'clock. Rhonda, are you there? Oops. Rhonda, are you there? Rhonda, are you there? You just.
Yes, I'm here, Judge. Yes.
All right, this motion to transfer venue, we're going to move it to November 13th at 2 o'clock.
Okay, November 13th at 2 p.m. Got it.
Okay, guys, you have a great rest of your day. Mr. Moody, try to get me that order. Make sure the order says that this was heard on October 23rd of 2023. And you guys have a great rest of your day, okay?
Thank you, Your Honor. You too.
Afternoon, Judge.
Afternoon. Is everyone here on this Zubarak case?
Yes, I believe so, Your Honor.
Yes, sir.
All right, Tony, let's go on the record on DC 234045 Zubarak versus the Valley View Park Estates Homeowners Association. Council, make your appearances.
David Welch on behalf of plaintiff.
Catherine Stark on behalf of defendant.
All right, you may proceed.
Thank you, Judge. And to give the court back a little bit of its time, we've reached, or we've limited this down a little bit. So there's basically two main issues that are kind of going on. One, the defendant has objected to production of documents and the interrogatories based on attorney-client privilege. We've requested a privilege log. We've not received one. The defendant, I guess, in their response has taken the position they do not need to produce a privilege log, which I think is incorrect because there's more than one law firm working here. So I would agree that they don't have to do a privilege log for communications with Gordon Reese, Ms. Stark, Mr. Bisey, Mr.
Mr. Welch, you muted yourself, or someone, maybe I did. I hope I didn't.
Sorry about that, Judge. Can you hear me now?
Yes.
And you need
All right,
to.
thank you.
What'd you say, Tony?
I need to repeat the names that you were going through.
Yes, ma'am. Ms. Stark, Mr. Bisey, or Mr. Kramer. There's another law firm. So this is an HOA. I know you're very familiar with this case, Judge.
Yeah.
There's another law firm, Casey Myers, and my client is a member of the HOA. So we're entitled to those communications with Mr. Myers' firm, or at a minimum, we're entitled to a privilege log of what they won't produce from Mr. Meyer's firm or any other firms. And they've not produced a privilege log, and it sounds like they're not going to or they won't unless ordered to. So that's issue number one with attorney-client privilege and their objections. Issue number two is I'm not even sure what, if anything, the defendants are withholding or not withholding, and it's impossible to understand based on the response to the discovery and the response to this motion. What makes me think they are withholding something is one of their items in their page 7 of their response, Judge. They say that HOA members communicate via their personal individual email accounts, and the HOA can't produce those. That's just not true. That's not how production of things work. It'd be like a company saying, oh, the CEO uses a Gmail account, so we're not going to produce any of the CEO's emails. No, if you're in the capacity and sending emails on behalf of the board and behalf of the HOA, they need to produce those. So those are the two issues, Judge. The emails, from what I can tell, they've not produced, and they're not willing to produce them, even though they have them. They know they're there. They're hiding behind, I guess, some kind of corporate veil, and then the attorney-client privilege issue. So those are really what we're limited down to, Judge, and I'll turn it over to counsel.
Response?
Yes, Your Honor. Counsel for plaintiff hasn't cited any authority supporting the fact that they allege we need to have a privilege log for attorney-client communications. And I just want to point to Rule 193.c specifically says that you don't have to include a privilege log for attorney-client communications. And they're just blindly saying that we have to include that on a privilege log. Again, counsel for plaintiff says that they are entitled to communications between other firms and the client. However, that's still covered by attorney-client privilege. We haven't withheld anything that's not privileged. And they really haven't specified specific types of categories of information they're trying to get. They're really just trying to invade the attorney-client privilege, and that's not our privilege to waive. The client has instructed us not to produce those documents. And again, as we asserted in our response, the HOA doesn't have access to personal emails of members. It's not something that they maintain in the ordinary course of business. We can't just force members to give us access to their email accounts. Again, this is really just, I think, either their third or fourth motion to compel. At this point, it's really hard to keep track of, but they're just trying to invade attorney-client privilege. We produced over 400 documents. And again, they haven't specifically pointed out what sort of documents or information they're trying to get. And defendants did produce an affidavit that shows proof that the information they're seeking is protected by attorney-client privilege. And as I stated in our response, we have to present a prima facie case that the information is privileged, which we did so with an affidavit, which case law supports. That's how you can present a prima facie case that it's covered by the privilege. And then that burden shifts to the party seeking production of the information to show that the privilege doesn't apply.
Response? You're
We can't hear
muted.
you.
We can't hear you. Can you hear me?
I'm sorry. Yes, Judge. I'm sorry. My phone was muted. The affidavit, I think Ms. Counsel is referring to, is an affidavit from herself. I'm not trying to evade anything. I'm trying to get the discovery I'm entitled to or get a privilege log. The privilege log exemption is very narrow and very limited. We're seeking information as it relates to multiple years in the past that are communications with the law firm that was paid well over $100,000 as just an individual firm. They're not one of the litigation firms. There's other documents we're seeking, and I guess appreciate the opportunity to ask Ms. Stark as the affiant what she did to determine what fell within what privilege, but I don't think we even need to go that far. I'm just looking for them to produce a privilege log of what they have, and then we can look and see what there is. That's the whole point of these types of procedures. And second of all, the fact that they can't produce documents from emails of their board members, that's just wrong. That's exactly how discovery is done on a corporation. Otherwise, every company in the world would say, well, we don't own the documents. It's the individuals that own the documents. That doesn't make sense. So I think on those two issues, they need to be ordered to produce a privilege log and at a minimum, produce the emails.
I mean, my understanding has always been that you're supposed to produce a privilege log unless it's core work product. So are you claiming all of the documents being withheld are core work product?
Or attorney-client privilege. If you look at Rule 192.3C, it provides, or 193.3C, it provides a specific exemption for attorney-client privileged information and work product information, a specific exemption to the privilege log requirement.
To answer your question, Judge, it is only core work product. It says, consults a lawyer with the view of obtaining professional legal services from a lawyer in the prosecution or defense of a specific claim in the litigation in which the discovery is requested, or concerning the litigation in which the discovery is requested or required.
What I'm going to order at this point is I'm going to order that a privilege log be produced for any documents being withheld in this case, with the exception based on privilege, with the exception of those documents that are exempted by Rule 193.1C. Does that make sense, Ms. Stark?
1C. So you're saying that doesn't include attorney-client privileged?
I'm saying that anything that's covered by 193.1C, you don't have to produce.
And Judge, just by way of example, of documents I know that exist that might help.
I'm sorry, it should be
everybody
190.
understand.
I apologize. It's 193.3C. Not 193.1. It's 193.3C.
Okay. But are you ruling that that doesn't encompass attorney-client communications, or?
I am ruling that you are ordered to produce a privilege log about all documents you're withholding based on privilege, with the exception of those documents that are covered by Rule 193.3C.
Okay. I don't think we're withholding anything that's not covered by that, but we will review and.
Go ahead and create an order to that effect.
Okay.
That says at the beginning that this was heard on October 23rd, 2023, and that gives the ruling I just gave you. Okay.
Okay. Thank you, Your Honor.
Thank you, guys. Anything
And
else?
Judge, yeah, what about the emails, please?
What's your response to the emails?
The emails, we can't compel production of personal email information in personal email accounts. The HOA members have their personal email accounts that they communicate on. We don't maintain a server that has access to that information.
Response.
Judge, the HOA is made up of individuals. So like Eric Pippin is the one who signed the interrogatories. They can make him sign a verification for an interrogatory, but they can't get him to produce his emails. That's just not how discovery works in Texas. They're board members, they're parties and members of the HOA. They need to produce their emails that they have.
May I respond, please?
Yeah, go ahead.
I think in that instance, we would need some sort of subpoena to invade their personal privacy. I mean, it's a personal email account.
But they're personal emails about the HOA, Judge. You don't get to use it as a sword and shield. You don't get to say it's personal, but I'm going to use it for HOA business. But at the same time, I'm not going to produce it because it's personal. It's how they're using it. They're using it on HOA behalf. I'm not looking for their, you know, Uber Eats orders or anything that's not related to the HOA. I'm just looking for the HOA emails that they have, their board members.
Yeah, I tend to think any emails from board members about HOA business that's been requested, you can't just shield that because it was a personal email account. But I don't think that that extends to everybody. So I would just say people who are board members, their emails would need to be produced that are responsive.
Understood. Thank you, Judge.
All right, anything else, guys?
I get 30 days for that production, Judge. Is that fine for
30
everybody?
days. 30 days.
Judge, I think this information has already been produced.
Okay.
I'm not certain on that, but I think we
Just
produced.
included as part of the order. You need to explore that and then
Okay,
let the other side know.
okay.
Give me
Thank
the
you.
order by this Wednesday, Ms. Stark.
Yes, Your Honor.
Remember, at the beginning, it needs to say this was heard on October 23rd.
And just so I'm clear, Ms. Stark is drafting the order. Is that right?
He is drafting the order.
Thank you,
And
Judge.